Today, we're diving into a really massive change in India's legal world. There's a brand new rulebook for how we prove truth in court, and it's a huge deal. So, what is it, and why does it matter so much? Let's get into it.
Just think about it for a second. In your everyday life, how do you prove something? Maybe you show a friend a text message, or you pull out a receipt for a purchase. You find some kind of proof, right? Well, when the stakes are as high as they are in a courtroom, you can't just go with a gut feeling. A society needs a clear, agreed-upon system to sort out what's a fact and what's just noise. You need a rulebook.
And in India, that rulebook just got one of the biggest updates in its entire modern history. It's called the Bharatiya Sakshya Adhiniyam, or BSA for short. Now, this is a big one because this new law completely replaces the old Indian Evidence Act, a law that had been around for over 150 years. So this isn't just a minor edit, it's a total rewrite from the ground up.
And when I say it's a rewrite, I mean it's comprehensive. The new BSA has 170 different sections, all spread out across 12 chapters. Every single one of them gets into the nitty-gritty of how evidence gets collected, presented, and then weighed in a court of law.
Now, it's really important to get what kind of law this is. The BSA is what's called a procedural law. That means it doesn't actually tell you what's a crime or what your rights are. Instead, it's the how-to manual for the courts. It sets out the rules of the game for presenting evidence, whether you're in a civil case or a criminal one. It's the machinery, not the final product. So what's the big idea behind this whole thing? What's the philosophy driving this new rulebook?
You know, a great clue actually comes from the word evidence itself. It comes from the Latin word evidere, which literally means to show or to prove. And that's exactly the point, to make the facts of a case clear for everyone to see.
And that right there, that's the absolute heart of it. The entire reason for having an evidence law like the BSI is to cut through all the confusion. It's built to help the court figure out what really happened and to stop it from getting bogged down by stuff that's irrelevant or, frankly, misleading. The BSA really boils this down to two main principles. First, stick to the point. The evidence has to be directly about the issue being disputed, no going off on tangents. And second, bring your A game. You have to present the best evidence you can get. That means the court wants the most reliable, direct proofs, not something that's shaky or secondhand.
All right, so that's the theory. But let's see how this all plays out in the real world. Where does this new rulebook actually have teeth?
The BSA's reach is pretty wide. It applies to all judicial proceedings in Indian courts, and that includes military court-martials. Thanks to cases like S.P. Jain versus the Director of Enforcement, we know it also covers certain financial cases. But it doesn't apply everywhere. It's not used by arbitrators or by what are known as quasi-judicial bodies. Think of things like administrative tribunals, which aren't formal courts. Now, going back to that best evidence idea, the BSA is very clear about hearsay. You know, that he said, she said stuff. Hearsay is basically secondhand information, like my friend told me that he saw. As a general rule, that's a no-go. The courts see it as just too unreliable to be allowed in as evidence. So if hearsay is out, what's in? Well, the law really values two stronger types of proof. First, you've got direct evidence. That's an eyewitness saying, I saw it happen. And then there's circumstantial evidence, which is a collection of facts that, when you put them all together, paint a very clear picture. These are the building blocks of a solid case. And all of this brings us to the bigger picture here, how this technical rulebook connects to the much grander search for justice. And this is where it gets really powerful. There's a direct line between this new law and the Indian Constitution itself. The BSA makes it crystal clear that no one can be forced to say something that would incriminate themselves. And that's not just some random rule. It's a direct mirror of the fundamental right that's protected under Article 20, Clause 3 of the Constitution. When you boil it all down, it comes back to this one simple, powerful idea. This quote says it all. The sole object of BSA is to obtain such evidence by which truth or point of dispute comes out. That's the mission. Every single rule is there to serve that one ultimate goal. But, and this is a really key point, a law like this is never really a closed book. The BSA isn't exhaustive. What that means is that Indian courts can still look to the long history of English common law and pass legal cases to help interpret it. It sets a modern foundation, but it doesn't build a restrictive cage around it. And that leaves us with one last, really fascinating question to think about. If this new rulebook is a living, breathing document designed for that relentless search for truth, what will its next chapter look like? As our world keeps changing, how will this law have to change with it? Well, that's a question only time can answer.